Of course, bad quality of reproduction of text or photo on the internet could be an attempt to the right of integrity, as it has just been pointed out in a French affair opposing the French publisher La Martinière against Google, or adoption of colors or sounds in a silent film is not allowed, and there are many other examples. But also the judge looks at damage on the spirit of the work, which means, for instance, putting a work in other compilation work may be derogatory to the integrity right. I would say that French interpretation of integrity right is larger than the British one, as I have understand, where it is limited to the reputation and honor of the author, as the Berne Convention said. The last right is the right of withdraw and retract. It's the right to take the work out of circulation and to stop, for instance, a contract passed with a company. But there is two conditions. First of all, the author has to give the compensation for the prejudice. And also, if he changes his mind, he has to give then to the first copyright holder the right of preference. There are many specific dispositions on certain type of works, but I have no time to detail it. Just say maybe a few words on what we call work of collaboration, which is a term for films or TV or radio program. There have been big discussion on the films issue before the war and after the war. And finally, we have specific rules for this kind of works. The main rule is that moral rights appears only when a film is finished, which is supposed to have received the agreement between the producer and the register or with other co-authors of the film. Then we have normal integrity rights on a film. No cuts, no colorization, publicity interruption can be refused, and all this. Another quick word on the fact that the working contract in France is indifferent on the titularity of rights, which means rights still belong to the authors, not to the employer. But there are two exceptions for the moral rights in computer work and also in civil servant activity in public service, where the integrity of right is little and it's straight to reputation and honor. So what are the character of the moral rights? First, perpetuity. The rights are transmitted after the death of the author to the heirs. That's a key issue, and it has created a large debate in France to whom rights should go after the death of the author, and how can a nation can control the use and non-use of the moral rights. The key issue concentrates on the right of disclosure, which was the more difficult one. And for that, we've put specific rules in the law, which means that first we look what is obviously the author's will, and then the right goes to the executor, then it goes to descendants, then it goes to husband or wife, and then the heirs, which is not the normal rule. And also a tribunal can defend this right after the author's death. The rights are unprescriptible. You still have it even if you don't use them. And also they are unwaivable. That's very important in France. Cession or transfer of moral rights is not permitted in contract, even in case where an author employed has already sold its economic rights, he can't sell his moral rights. I would add very quickly that the rights are not discernible. They have to be applied. They have a caractère d'ordre public. I don't know how to say that in English. And there is a discretionary character of moral rights, which means that a judge can't appreciate if the author is legitimate or not to act. Maybe in special case, he can use another theory, the theory of abus de droit. So very briefly, I would summarize the main difference between France and other copyright countries. Preeminence of moral rights in France, authors own moral rights, not the director or not an employer. There is a large cover of rights with small exception, whereas we have large exception in other countries. Of course, we have full rights, where very often there are only two rights, in paternity and integrity. And moral rights are perpetual and unwaivable, whereas they stop upon the end of copyright in UK, and they can be waived. So what are the effects of moral rights in France? It's a difficult question because it's not easy to evaluate the economical impact of moral rights. First, what is the impact in practice on creators? Regarding remuneration, I would say that moral rights gives the authors clearly the power to prevent a new exploitation. It is a very big power in front of the company which exploits works. It might counterbalance the weakness of the individual author in front of the major company, but the author is not really stronger and richer afterwards. Arguing with his moral rights may condemn the author not to benefit from new royalties. So I would say that this contributes to make economy less fluid, maybe. There are, for instance, I can speak about the example of a musician who can be opposed to a company who, for instance, put a video from one platform to the other one. He can say that that's an attempt to his integrity right. Or a journalist can refuse that a company put his article in a database because there will be near other articles, so it could be an attempt to his integrity right. Regarding bargaining power, no doubt that moral rights are a limitation of the power of the copyright holders, a break to reutilization of the works. Is it a power to negotiate or a dissuasive power? That's a difficult question. Moral rights faces new target in digital world, that's sure, which has given them a new actuality in many debates around IP. The first characteristic of digital work is that work are copied very easily. Copy is a traditional problem for companies, for capitalism. It's not new, but the size of the problem is very new. But the second characteristic of digital world is important as well. New possibility of intervention exists with the development of social network and Web 2.0 with pro-aim practices. The public use the work in a very different way than what the authors might expected. The public need access to works in order to interfere on works, transform, use them, and produce new works. That's a new situation because the authors face not only difficulties with intermediaries, but also with the public regarding moral rights. Okay, thank you. On the other hand, there is a second movement. Digital world is a multiplying factor of the number of authors who express themselves. And also moral rights act also as a multiplying factor to create problems. So maybe one day we'll see an author which will argue that Google references or publicity on a provider is an attempt to his moral rights. Very quickly, regarding recognition, no doubt that the right of integrity and paternity contribute to act recognition of the author. And I would say for that, moral rights have a double purpose, a private and also a public aspect, because it makes a protection of the private it makes a protection of the public interest in preserving the integrity of cultural property. Public is interested in stability of meaning, value, and cultural products, and therefore in preserving the integrity of the work. Also, in digital world, issues concerning the authority of information and cultural products, its reliability and its currency became key. The cultural interest of moral rights became also a social utility. So what impact moral rights have on the supply of creative work? It's a tricky question. Moral rights can't serve the same social and economic interests, encouraging dissemination as they don't create the same incentive as copyright does. But there is a cultural interest for the public with moral rights, as I have pointed out. The need for the social, cultural role played by the moral rights has been increasing. The two aspects of moral rights, circulation and respect, are very linked, and both are involved in the social utility of moral rights. As a conclusion, I would say that the perspective on moral rights might be optimistic. Intellectual property policy is designed to further the interests of society in an expanding supply of reliable and available creative work. Copyright can supply an available creative work, and moral rights can supply reliability on the creative work. European Commission, with its work on creative industry, put in the middle of the economical and judicial discussion the contribution of the creator and the conception of an economy which is not only concerned by facilitating exploitation of copyrights, but also by the expression of creation. As what is property and what is common is twinned around in immaterial domain, IP policy is facing again today the problem of a fair articulation between the defense of the creator's right and the defense of a culture as a human community property. Thank you.